So today, you and I will be examining the first witness statement of Johnny Depp. Now, I always like documents like this because it goes to the documentation without the speculation of media, allowing you and I to decide where exactly the merit lies. Now, it goes further than that media speculation, and it talks about accusations and how they tried to take away Harry Potter from Johnny Depp. He decides to take action against the Son in this, and you find out a lot about the Son, you find out a lot about the Nameless One, and in this you also find out why Johnny Depp, he hasn't talked about this stuff publicly before, because you know what? As part of 2016's legal bindings, he was never supposed to, but that didn't stop another party, as is also addressed in this. Man, this is a good document. So hey there, so today we return to that wonderful World of Johnny Depp coverage, but before we get started, let me say one brief thing. If you enjoyed this content, consider subscribing to the channel and sharing videos. And if you have subscribed to the channel, make sure that you're still subscribed because the platform, it isn't in love with us. Also, if you like this content, consider checking out the links in the description. They definitely help the channel out. And as always, thank you very much for being here. So a few things about this document before proceeding. This is the first witness statement of Johnny Depp. This is an association with the claims brought forth against the Son, but it also details all of the stuff that he's utilizing in that other case as well. Now it's a lengthy document. We will skip certain portions of it as we move because it's a lot of legalese or it doesn't matter in there, but still this will take some time to cover, but it will be worth it. Now when I go through this too, I will redact certain names or certain words. Apologies for that in advance, but that's the platform. That's not me. So when we go through this, number one, they're the claimant, of course. Number two, saying, hey, as far as I know, this stuff is factual. Number three, it lays out exactly why this is filed. Number four, for the purposes of preparing this witness statement, that gives who this is prepared with and what kind of exhibit this is and on. So the background for this. These proceedings, they relate to an article published by the defendants, which appeared online on April the 27th, 2018, and in hard copy, April 28th, 2018. Now, as set out in the particulars of claim, paragraph 10, the article included words which I contend meant and were understood to mean that I was guilty on overwhelming evidence of serious DV against a Nameless One, causing significant injury and leading to her fearing for her life. The article further suggested that I was constrained to pay no less than $5 million to compensate the Nameless One for my alleged behavior, that my actions resulted in me being subjected to a continuing court restraining order, and that for that reason, I am not fit to work in the film industry. That's quite a bit to lay out there too. They tried to ruin the man there. Now this stuff is interesting because it allows Johnny Depp to talk about his truth in this. So he issues a proceeding against the defendants, claiming damages for libel and an injunction. Now the defense, they file a defense against this, and they rely on a defense of truth in relations to the meaning, quote, the claimant, you can see those words there, B-E-A-T, his wife, the Nameless One. Now this person accepts in his witness statement at paragraph 5, the defense was pleaded on the basis of information in the U.S. court's documents. One of the allegations made by the Nameless One in those documents relates to an alleged incident that took place on May 21st, 2016. Now, as truth of defense was put on record, I was obliged pursuant to put in a reply addressing the factual allegations relied on by the defendants in their defense. As more fully set out in the reply, 2 police officers who attended the scene of the incident alleged by the Nameless One on the 21st of May 2016, shortly after the incident occurred, and who had released an exculpatory public statement which the first defendant had reported, provided 2 separate depositions describing what they saw, stating that they found that there were no injuries or bruising or swelling to the Nameless One's face, and indeed the scene bore no resemblance to that described by each of the Nameless One and her friend under oath. Despite the Nameless One's sworn deposition to the contrary, the Nameless One had told them to their faces that nothing had happened and made no mention of any, I'm going to say, accosting. She said she was not injured and refused medical treatment. In particular, they referred to the following. The phone did not hit the nameless one on the face or elsewhere, nor did the claimant pull the nameless one's hair or strike her or grab her face or touch her. Two police officers who attended the apartment directly after the alleged incident and interviewed the nameless one twice in good light saw no injuries or bruising or swelling to the nameless one's face or elsewhere. When one of the officers asked the nameless one what had happened, she responded nothing. When the nameless one was asked, there's a word missing here, if she was hurt, she shook her head. The nameless one did not say to the officers that she had been accosted, and when asked if she had been injured in any way, she said that she wasn't injured and refused medical treatment. The nameless one said she did not want to make a police report and that there was nothing wrong. So continuing. Further, both of these officers subsequently confirmed their evidence to this effect in separate depositions. They tell where that's at, and the reply continues. In the premises, if and to the extent that Miss Pennington, this is one of the friends of the nameless one, subsequently took a photograph of the nameless one's face, as pleaded in paragraph 8G, and which was not admitted. It was not a photograph of any injury caused by the claimant. In the subsequent proceedings brought by the nameless one, hard copy photographs were put in evidence, but neither the original images nor the associated metadata were produced. Now that's interesting here too, because they say, hey, these pictures, we don't know where they came from. After the fact, those were added in, but there were no original images and no metadata saying exactly where they came from. Continuing. This is highly significant and exculpatory evidence that has been ignored by the defendants to my detriment. The defendants appear to have made no attempt to check their facts prior to publication or to ascertain whether there was any basis on which they could defend an action. If they did do so, they must have made a positive decision to present a totally one-sided picture, leaving out my side of the story and pretending it either did not exist or it was not worth considering. Further, in the event that this matter goes to trial, I will rely, amongst other things, on the following evidence to support my position in respect of the factual allegations made by the defendants in their defense. So this first declaration is by Sean Bett. That's one of Johnny Depp's bodyguards, and it pains me to know that right off the top of my head. I know his bodyguard's name. I spend too much time looking at these documents. But he said here, I was working and present on the evening of May 21st, 2016, and was a witness to the altercation between Depp and that other person. Within approximately 15 to 20 minutes, we heard the nameless one screaming at the top of her lungs and immediately entered the penthouse. Johnny was standing approximately 20 feet away from the nameless one, who was sitting by the couch. As soon as the nameless one noticed that we had entered the unit, her demeanor changed, and she pointed at him and yelled to us, "If he hits me one more time, I'm calling the police." My vision is quite good. I was able to ascertain that the nameless one was wearing little to no makeup. Her skin is quite pale. She had no red marks or any evidence of any bruises or abrasions to her face or her body. Although Johnny was visibly upset at having been accused of hitting the nameless one, he never came closer than 20 feet to her during the time I was able to observe him. There was no smashed glass that I noticed in the apartment at any time. So next comes Jerry Judge, yet another bodyguard, and again, I can't believe I know these names without looking them up. He notes, I was with Johnny Depp throughout the day on the 21st of May 2016, escorted him, along with Sean Bett, to the location that all of this stuff took place. I did not observe Johnny drink or take anything. He was sober in all respects when we arrived at the loft between the hours approximately of 7 and 7:30. About 30 minutes or less later, Sean and I re-entered the loft upon hearing raised voices, although the nameless ones chiefly from within. I did not observe Johnny touch or even approach the nameless one. In fact, they remained approximately 10 feet apart during that period of time that I observed them. I did not observe Johnny break anything, including wine glasses or bottles in the loft or outside the loft in the hallway. I did observe 2 tall glasses of wine in the loft, but they were intact. I did not observe shattered glass anywhere in the loft. Now, the declaration of the nameless one's Eastern Columbia building friend and neighbor, now I'm actually going to cover that in depth another time, in which he says, on May 21st, 2016, the next day, it was my birthday, and I was leaving the condominium building during the day and walked out into our shared hallway. I saw there were a number of people gathered. Now, you notice it skips a bit. We then walked back to the open doorway of Penthouse 1, where I stood in front of the nameless one face to face. The nameless one then stated all of a sudden in a very animated and excited voice, "He hit me. He threw a phone and he hit me." The nameless one then stretched her neck and head forward for me to look at her face. The morning light in the hallway allowed me to see her face clearly, and her face looked to me was without makeup as she faced me. I stated, "I don't see anything," and I stated, "It must be all that beauty that's outshining everything from one side of your face to the other." And then the nameless one smiled and laughed blushingly as she pulled back her neck and head and leaned against the doorway. I was a foot away from her face at this point, and I saw no redness or swelling or marks of any kind on her face as she was close to me and looking directly at me. The next day, Monday, May 23rd, 2016, I heard a knock at my door and went to the door. It was the nameless one standing at my door. Nameless one asked if I would take her key and let the cleaning lady into the residence later that day because she wanted to leave the condo. I apologized and told her no, I was ill, wasn't up to it, and she asked one of the security guys downstairs to do it. There was plenty of light in the hallway as she stood in my doorway, and I once again clearly saw her face. There were no marks of any kind on either side of her face. There was no bruises or scratches or any dark spots of any kind. She was at most 2 feet away from me, and her hair was down. During the week of May 23rd to May 27th, 2016, I saw the nameless one on multiple occasions in and around our shared residence building. In all instances, I had a clear opportunity to see the nameless one's face clearly, and there were no visible marks on the nameless one's face at all. Now, this person subsequently speaks to the nameless one. She replies, "I told Johnny I don't want anything from him. The lawyers are doing all of this." So you notice that. Basically, didn't see anything on the person. Plus, I take no blame in it, which was also noted in text messages that I talked about in a different video. So then you have the deposition of Trinity Esperanza, the head of desk staffing and security at the Eastern Columbia building. And this person says she, the nameless one, said that she had close connections with People magazine and asked if we could help her. She just needed help because of that quote that was put out there. It was stating that the front desk confirmed that we saw her without a mark on her face after the incident had occurred. We, the Eastern Columbia building staff, we became aware of the allegations. And so Alex and I discussed that we saw that we knew that we didn't have the mark all week long and that she now had it on Friday. I said to both of them, I saw her and she had nothing on her face. We talked about it. Obviously, it's a huge propaganda. So we talked about it and we discussed that we saw her previously that week and there was nothing on her face. And then on Friday, May 27th, 6 days after she alleged we're going to call that WB, we saw that she had a mark on her face. That does not sound good, does it? Now, here's deposition from a Cornelius Harris, another employee from the Eastern Columbia building, saying, question, okay, did you work on Sunday, May 22nd? I did. And did you see the nameless one that day? I did. Where was the nameless one when you saw her that day? She came to the front desk. She asked for a package that she received. The nameless one said, what I'm expecting is wine, and I gave her a wine that she was expecting, and she was like, thanks. So you had a conversation with the nameless one? Yes, for approximately, I want to say the whole interaction was probably 5 to 8 minutes. Did you have a chance to? Did you see the nameless one's face during your conversation with her that day? Yes. And did the nameless one appear to be wearing makeup? If so, very minimal. Did you see any bruising on the nameless one's face that day? I did not. Did you notice any swelling to her face? I did not. Any red marks? Did not. Any cuts? Did not. Okay. Any injuries of any kind to her face? No. Then you have security camera footage from the Eastern Columbia building that's actually put in. You have text messages that are added from Catherine Kendall, a primary source for a certain hashtag movement in that article, and the reporter from the first defendant that interviewed her. So the agreement, as referred to in paragraph 8 of the witness statement there, I was married to the nameless one from February 2015 to January 2017. Not even 2 freaking years there. In May 2016, the nameless one filed for divorce, again right after his mother died. At the same time, the nameless one sought DVRO, that's what that's called, a DVRO, against me. On the 27th of May 2016, the Superior Court of California, Court of Los Angeles, the California court granted a temporary RO on an ex parte basis, the ROs. I intended to challenge the ROs in open court, but before I was able to do so, the nameless one and I came to an agreement on August 2016, which dealt with all the terms of our divorce settlement, including a financial settlement in the respect of the divorce. Subsequently, the marriage was dissolved on the 13th of January 2017. Now, this part is pretty good here. So the terms of the agreement are set out in the stipulated judgment dissolution of marriage exhibited to this person's witness statement. As is made clear on page 144, the judgment is a public document. Now, as recorded in that, the nameless one dismissed her request for DVRO with prejudice on the 16th of August 2016. The same paragraph records that both the nameless one and I agree that neither of us was the prevailing party. The first defendant knew about this prior to the publication because it reported that in an article on August 17, 2016, and they record that here. So paragraph 8.3 of the agreement records the agreement that neither I nor the nameless one will pursue civil actions against the other, including for libel, slander, or defamation, for any reason in any jurisdiction, for anything that occurred for the time period through and including the execution of that on August 15th to 16th, 2016. So paragraph 8.4 of the agreement records that the nameless one had not filed a police report claiming any criminal wrongdoing on my part. It continues, the nameless one shall not be limited in any way with fully complying with any valid legal process or cooperating with any law enforcement investigation. In the event that the nameless one is served with any valid legal process relating in any way to Mr. Depp and or this dissolution action, the nameless one shall notify Mr. Depp in writing within 48 hours of receipt of that legal process so that Mr. Depp may make any and all appropriate and legal objections to such process as he deems necessary. Now, the confidentiality provisions are set forth in that. Now, paragraph 20.1 relates to information on the internet and the media. 20.3 records the agreement that neither party to the agreement will make or cause to be any of derogatory, disparaging, critical, or accusatory statement, either directly or indirectly, expressed or implied, oral or written concerning the other party, whether said statement are believed to be true or not. The provision has an express carved out except as required by law. Ooh, so that it goes with the internet and the media, and you can see a violation there by somebody. It's a big one. I mean a big one. Similarly, paragraph 20.4 states, the foregoing shall not be construed or enforced in a manner that would restrict the disclosing party from responding truthfully in response to any inquiry required by legal process. So the only out is a legal process here. Now from here, we're going to skip a few things. Why? Because this becomes a confidentiality argument. Basically, Johnny Depp is told you shouldn't be able to go out and defend yourself at all because when you do, you bring in a third party to this, and that third party, they're not supposed to know anything about this from your mouth. Now, this is what his lawyers say about this. Our client can hardly be criticized for defending himself against public accusations which threaten to destroy his career and are totally false. In the case of the Sun paper and Mr. Wooten, it appears to be their intention that our client's career should be destroyed since the thrust of the article sued on is to extricate J.K. Rowling for standing behind the casting of our client in a film instead of recasting another actor. actor in the role. You suggesting that our client is guilty of abuse of the court's process, but he has done literally nothing to obstruct, impede, or interfere with your client's defense of the action. Neither does he have any intention to do so. Your client must be expected to be able to prove their case before putting a defense of truth on the record. If they cannot now do so, that is nothing whatsoever to do with our client, who, we repeat, has done literally nothing wrong to obstruct, impede, or interfere with your client's defense of the action. Basically, these folks, they want the nameless one to be able to go out and get a release, and Depp's team is saying you can do that in a limited action, but you can't do that wholesale. You can't go out and attack. Now, what's amazing about this is there's a fit thrown about it, too. And they bring up the hypocrisy of this, which I find to be beautiful, considering we might actually have a lawsuit on this stuff, too. Now, in addition, it says the position set out by Ms. Ross, namely that the nameless one feels bound by confidentiality provisions of her agreement, is inconsistent with various sly but unmistakable comments that she has herself made in the media after the date of the agreement. For example, and remember, this is the crux to the stuff going on between the nameless one and Depp here in Part B, but also in Part A, really. A, 25th of November, 2016, PSA on, we're going to call that V Against Women, that the nameless one produced and distributed on the internet with hashtag girlgaze, and which refers indirectly but unambiguously to her allegations that I had, what was supposedly done there. When it happens in your home, behind closed doors with someone you love, it's not as straightforward, skip some here, as a woman having gone through this in a public stage on a public arena. So yeah, you can see who that's pointed at. Then there was the December 20th, 2018 op-ed with the Washington Post titled, I spoke up against, we're going to call that SV, and faced our culture's wrath. Now, the nameless one did not name me, but pointed unambiguously to the time period of her false allegations against me for the avoidance of anyone's doubt to whom she is referring and accusing. 2 years ago, I became a public figure representing, we're going to call that DV, even though that last word changes, and I felt the full force of our culture's wrath for women who speak out. Remember, that's one of 3 sentences that stuck against her, too. Yeah, that could cost $50 million freaking dollars. Now, as far as the application portion is concerned, we can skip 39 and then say, I understand that the defendants will be submitting that I am abusing the court's process. I find that highly offensive. It's the defendants who have chosen to both publish and defend a true, very serious false allegation against me. They choose to revive false accusations against me, knowing that there was a settlement between my ex and I. By pleading truth, they are forcing me to give evidence about a matter which had been settled. Again, they don't want him going out and setting the record straight or suing them. I noted in a recent article published by the HollywoodReporter.com website, it has been reported by my legal team has refused to allow the nameless one to give evidence and has even threatened to sue her for violating her NDA if she does. A copy of the relevant article is attached there. It is important for me to defend against this misinformation. As far as I understand it, no such threat has ever been made, and my legal team has not refused to allow this to happen. I wish to make clear that I have no concern about the nameless one being called as a defendant. My primary objective in bringing these proceedings is to ensure, as far as is possible, that other media outlets will not repeat similar allegations to those published by the defendants. I knew from the onset there was a possibility, in the event truth was pleaded, that this litigation would result in a trial involving determination of the facts in respect of the alleged underlying events. I find it insulting that the defendants are now portraying me as seeking vindication on a false basis. I do not believe that it was ever the intention of the parties to my divorce proceeding that the agreement should prevent either one of us suing a third party as opposed to each other for libel. Once the truth defense was put on record, I was obliged to respond with that defense in my reply. I intended to give evidence of the facts pleaded in that reply. Now, prior publicity, this is interesting too. Those allegations were never tested in California court. There was, however, a huge amount of publicity publicity about these allegations. That lawyer there refers to this coverage in paragraph 12 of his witness statement, but does make it clear that much of the coverage was published prior to the agreement and or contained information which contradicted the nameless one's position. For example, the Variety article, which was referred to in this, contains a statement from law enforcement officials stating that investigators had found no evidence of any of this stuff and that the nameless one did not want to file a criminal report. This article was published very shortly after the nameless one had obtained the temporary RO. ET on publication that is also noted in this records that the nameless one had withdrawn a request for the RO. Mail Online article in paragraph that this person also notes was shortly published after the nameless one had obtained the RO, and again including information from the LAPD. There was an article by I.O. Tillett, right? This is one of the friends of the nameless one referred to in that. Does not name me, although I accept that it relates to me. It was published prior to the settlement agreement. I could not take action against articles that fairly and accurately purported court proceedings, unlike the articles relied on by the defendants. The Sun article I am suing on was published a long time after the agreement. It does not contain any denial on my part or the evidence which contradicted the nameless one's account, nor does it record that the nameless one withdrew the RO. It alleges that I paid the nameless one $5 million in respect to DV allegations. For those reasons, I do not accept the assertion that the articles listed above provide the context in which the Sun's article was published. The article was deliberately aimed at driving me out of the industry in which I've worked my entire life and which to continue working in. I am confident I can disprove the defendant's allegations for the reasons set forth, noted there, whether the nameless one gives evidence or not. Comments to the press. So there's comments of this witness statement. This person refers to the GQ article and Entertainment Weekly article. In reliance on those articles, he states that I am bringing this case to convince the world that the nameless one lied when she accused him of DV. That is incorrect. My purpose in bringing this is to stop false and defamatory publications. So then the nameless one's position. Some of this is interesting here too. I have addressed the correspondence from the nameless one's lawyers above. That was all the stuff we were skipping around there. So in the paragraph 32 of his witness statement, he notes that the nameless one has no desire to set aside the divorce agreement nor to become involved in legal proceedings in the U.S. which will involve further costs or publicity. The absurdity of this statement was shown on the 12th of October 2018 when the nameless one served a notice of arbitration demand dated 11th of October 2018 that she hoped was resolved by, there's a person here, in the 3rd of January 2019, Hollywood Reporter article titled, I was petrified of a monster. Johnny Depp, the nameless one's legal documents shed new light on dual, you can see that word, accounts. The nameless one's lawyer, Eric George, disclosed the arbitration they were seeking as a desperate measure and inaccurately described both issues supposedly at stake and the status of non-existent proceedings. Mr. Depp's ongoing defamation and violation of party confidentiality agreement is already the subject of pending arbitration, aka he's the bad guy for going out and trying to help himself there. So they conclude here, I do not believe it is right or fair that defendants should be permitted to defame me, plead truth, and then strip me of my ability to defend myself and defend my rights because the nameless one protests that she cannot give evidence without breaching an agreement. If the nameless one believes that it is necessary for the agreement to be varied, she should address those issues before a California court. For the avoidance of any doubt, I have taken no position as to whether the nameless one can provide evidence in these proceedings. Now, to note with this, the nameless one will be able to provide their side of things. They get to do it behind closed doors too, and I find that to be really, really disappointing. Why? Because a lot of this stuff has already been out in the public, and you can see the inconsistencies already. I'd like to see the rest of it. I'd like to see how inconsistent it is. And at the end of the day, since they decided to fight this war in the media, I would like to be able to see how that tide turns and how, the same words that they threw out there, they could be used against them. But anyway, you tell me what you think about this stuff. Now, to close, I want to say thank you for showing up. Thank you for participating. You make these endeavors possible. Without you, none of this stuff works, so thank you. I don't want to monopolize your time either, but I do want to thank you for it. And I also want to say, if you're a person that's having difficulties these days, you can't make ends meet, make sure that you ask people for help. That includes myself. Now, I can't pay your bills. I'm not offering money here, but I am offering assistance with things like baby formula, canned goods, and on. You can write the email associated with this account. You can hit me up at ThatUmbrella on Twitter. Those kind of ways are ways to get in touch with me. And again, I hope everyone is doing well out there, and make sure that you reach out, because from my family to your family and from other people as well, we're all in this together. And we wish you a good day.